Okay. All right, guys. So let me just quickly give you a brief summary of where we are at the moment. Obviously the judgment, the most important thing is that the judgment from Judge de Wet came out in April, and we know that she has declared it a Ponzi scheme. There are certain things in there that are minor errors that can be argued, but the overall principle of her declaration is very difficult to argue. Now, just staying on this and looking at what's happening on that, and Advocate Hendrik and Pierre Dutoit, when I finish the summary, I'll take it bit by bit, and if you have any comments to add to that, then please do so. Where we are at the moment is that that has been appealed by Marx's lawyers, and they are appealing. They are asking for leave to appeal. Judge de Wet can decide to give them leave to appeal. They've listed a whole lot of reasons why. But in the end, all it will be is a permission to appeal. If they get a permission to appeal, obviously that will then go to a hearing, official hearing. If however, she denies it, they can go to the Court of Appeal and ask for whether they can appeal. Honestly, I don't think that anything will change. If they get the appeal, goes to court, we're still going to end up with something that's going to be declared a Ponzi scheme. So at this stage, the way I see it, all it does is it delays us getting to the money. It delays the advocates and the solicitors getting to the money and getting that paid out. So we'll see what Judge de Wet does about this, but honestly, I think it is in the net loser's best interest now to set this whole thing, for this thing to be settled. And that's my opinion, obviously. Would you like to comment on that, Advocate Hendrik van Staden, on that specific topic?
Chris, I am in agreement with you, and we've reached that stage of this whole MTI saga where the important part is that the litigation is more or less complete, except now for the appeal by the Marxists, and then there's still the outstanding judgment with regards to what will be the calculation value that will be used to determine the claims that can be instituted by the investors, and then also the other judgment that came out was the settlement that the liquidators are going to go in with SARS, which is, and here can just correct me, it's just under 300 million instead of the initial over 900 million which they claimed. So at least that there will be some funds left in the pot to pay out the investors.
Yeah, I think just dealing with the de Wet thing, I think at this stage, honestly, it's in the best interest of the investors that everybody just lets it be for what it is. And where we are at the moment, I think that if you look in the light of the fact that we are sitting with a Ponzi scheme, the agreement which has been actually reached with SARS was in effect in line with the South African Constitution. It brings it back into line with the South African Constitution. I don't think we need to go into legal aspects as far as that is concerned, and that makes it a really good point of view. So I think maybe Pierre, if you want to just comment on that. I think what I'd like to do is just look at the open edges we've got, and then look at our way forward so that we can make just discuss it so that we can make an informed decision as what's the best action from our side at this stage once we know what all the legal issues are. There are three issues. The declaratory order is obviously still outstanding, and it's difficult from my point of view to see that the declaratory order will actually come out until such time as this whole settle around the Ponzi thing debate has been settled and that appeal is not going on. But I think the SARS thing is really, really important, because the alternatives could end up in a creon, and it could be really bad for the investors. The settlement that I think we should support the settlement 100%. That's my view, and we can talk around that and just discuss that. So Pierre, I'll give this to you, and then if you can comment on that for us.
Thank you, Chris. Just firstly on the outstanding judgments, it is unfortunate that we are experiencing a delay currently with a few matters that we're busy with. We do have, I think, as we've communicated to everyone, we do have a date for the application for leave to appeal by the Marxists in the Ponzi application that's set down for coming Friday, the 23rd of June. We remain confident that it's most unlikely, based on my experience over many years, it's very unlikely that they will receive leave to appeal that judgment. If they receive leave, then the matter will either go to the full bench of the High Court in Cape Town or to the appeal court, the SCA that we call the Supreme Court of Appeal in Bloemfontein. But I do really think it's unlikely that they will go that route. You were right. If they or refuse leave to appeal, they can still approach the Supreme Court of Appeal. We call it a petition in South Africa, petition for leave to appeal. So you basically just repeat your request for leave to appeal, but you address that request for leave to appeal to the Supreme Court of Appeal. That is all done on paper, so in other words, on affidavit. We will oppose that, and it doesn't help me speculate. I can just say that we're confident that that the judgment will stand. We're confident about that, and hopefully by Friday or shortly after next week Friday, we will have clarity on that. Considering we refer to it as the declarative application. That's the one where we've asked the court to just confirm to us the manner in which the liquidators are dealing with the quantification of the claims of investors who's lost money. We were hoping to have it by now. One can again speculate that the judge, considering that matter, may be waiting for a final decision on the Ponzi. That's normally not how it works, but it's not impossible. They do, they can actually communicate to one another, and it may be that the judge, considering the matter, is still waiting just to see what's happening on Friday. But we do expect a judgment on that score, hopefully very shortly. In the interim, that's not really a delay because, as you all would know, the approach that the liquidators are following on quantifying claims by investors currently is as we've asked the court to do. It's on the same basis as we asked the court. So that then leaves us with the SARS matter. The SARS matter is a matter that we will have to finalize and get a judgment on that before the liquidators will be in a position to prepare and actually lodge the first liquidation and distribution account. Up until now, we haven't received any indication that anybody wants to oppose that on the return date. As you would know, the return date, if I'm not mistaken, that's in early November. I think it's 2 November.
Yeah.
Yes. So I'm not sure whether you guys want me to go into a little bit more detail with regard to that matter. It's a bit of it's a very technical field. We had opinions of at least 4 counsels specializing in tax-related matters, and they are all of the firm view that the settlement that is currently on the table is a good one. Let me perhaps say this, that the decision to settle is based on we can fight such, and I think it's a very interesting academic debate whether we can actually say there's no tax payable at all. There's definitely an argument to be made out on an academic level, but considering the risks that you always have with litigation, considering that the current latest or the last verdict on that in the Supreme Court of Appeal South Africa, the well-known MP finance case, is still currently good law in South Africa. It just basically boils down to where you've got a fraudulent scheme, all the income, all the investments that you derive from investors are considered to be income because a thief derives his income from defrauding people. So that's the basis. So it boils down to if we do not settle, it will be a 6 or a nix. So if we right, then there's no tax payable, and if we're wrong, then the claim of SARS that we all know stood at around about 930 million rand will then stand. So that will basically wipe out what we currently have available for credit.
But surely SARS's claim can also be adjusted if you bring in more money again, because then everything that you bring in becomes taxable. If it goes that way, I think that's always the thing that we're faced here. I think a settlement on the basis, the opinion that I read on that was that that you're matching what is constitutionally also right in terms of the law, which to me makes a lot of sense. I don't know if there is, Hendrik, if you have any comments on that. What do you feel about that settlement, Hendrik? If you could just give us a short. Right.
As Pierre said correctly, the case you referred to was based on that Mariki from Creon, and in which the court ruled that the income that she received from the investors must be taxed. And as Pierre correctly pointed out, we can either try to stop it, and then we run the risk of losing everything that is available in the pot, which is available for payment to the investors, or if we continue and we support the liquidators, it means at least we know that there's a substantial amount of funds in the pot so that at least the investors can get a decent payment. And then also it must all be taken into account that there might be net winners that will be willing to come and settle, which will then again increase the amount of funds that will be available to the investors. There's just one small aspect that I just want to clarify, and Pierre can also tell me if I'm right or wrong in that regard. There's a lot of investors who's asking now that are net losers, are they going to be taxed on that money they will receive? According to me, if you invested funds and you did not make a return on that, that is greater than the amount invested and lost, you're not due to pay tax. However, if you were a net winner, you might be liable for income tax for that amount that is above the tax exemption that you are allowed yearly on investment returns.
Pierre, would you like to comment on that?
Chris, unfortunately, Hendrik broke up there for a moment, but I got the in of it, and I think he's talking about the question whether investors will have to pay tax on what they've, if they made a profit. Am I right?
Yes, you're right, Pierre. They will have that. My view is that they will have to. However, net losers won't have to pay income tax if they did not make a profit from MTI.
Yeah,
you can just.
I agree with that, but I just want to make it clear that I am definitely not here to give tax advice for investors. I think that's something that it will obviously depend on numerous factors with regard to your whole portfolio and whether you are making a regular income on investments, etc. But I would rather not venture myself on that topic now at this stage, Chris. I would prefer to just keep it limited to the tax affairs of the company liquidation.
Okay. Is there? I think the one thing that is on everybody's mind as a question is the fact that possibly one of the things that's on a lot of people's minds is if there is any case, and I think that the liquidators can tell us this, and if anybody else can tell us. My question here is: has there been any evidence whatsoever anywhere that there has been trading, or there was trading, or that there was an increase in the assets as a result, apart from the natural growth increase of the actual Bitcoin? There was, as far as I can see, with all the evidence since the investigation by the financial authorities, by the investigations by the liquidators, having access to the back end, having access to the FX accounts, having access to all the other bank accounts and everything else, the only monies that was actually paid out was monies that other people had put into the system. And the monies that got lost was not from trading profits. As far as I'm concerned, there have been no evidence of any trading profits of any kind whatsoever. In actual fact, I think there are only losses. There are trading losses. Am I correct in that summation? Pierre, maybe Herman, you guys have got information I don't have.
First, let me take that one. I can definitely confirm to you that all the investigations by all the forensic experts have come up with the same result, and that is the only trading that we can establish was that was done through FX choice. That trading yielded a net loss of approximately 500, and I'm not sure now, sorry, it's about 580, I think 580 Bitcoin were lost in that. And that's one of the deductions that we managed to, as part of the settlement with SARS, they acknowledged that loss. So they've also confirmed the loss that was suffered via that trading. But absolutely no other proof of any income for MTI except receiving Bitcoin from investors whatsoever.
Okay, and that was a total loss. It got lost and was a total loss, to be truthful. Yeah. Can I roll back now? Just in summary, where we are at the moment. So we're waiting for one or two issues to be resolved, the declaratory order to be resolved. We're waiting for the appeal to be declined and whatever's going to happen after that. Is there a possibility that if the appeal is declined, that you would be able to move forward if you could move the court case which is scheduled for November? Because I trust that you need to wait to be able to submit the final accounts. You need to have a decision on the SARS case on the 3rd of November for that to be fixed in law, so that you can make the payments then to do the accounts for the company. Is there a possibility, because this is everybody's question, and it's the one that I get from 100 times a day: when am I going to get my money back? So the best case scenario, the way I see it at the moment, is that the appeal is turned down. Do you need confirmation that there is going to be, or is there a time limit on when they need to submit the application to the Supreme Court in Bloemfontein to appeal? Is there a time limit to that? Or will it be a natural, they need to give notice of something like that happening? And will you then be able to say, okay, 30 days later or 20 days later, whatever it is, okay, now the vet's judgment stands and we can now move on to the next thing, which is the SARS thing. All right. Can you maybe roll that for us a little bit, Pierre? And then maybe look at, is it possible to move that application back so that we can get the funds sorted sooner?
Chris, just on the first point, that once the application for leave to appeal is dismissed by just the vet, then you have 30 days, 1 month, to proceed with an application for what we call the petition to the SCA. But in that period, we carry on with the matter as if there's no appeal pending until they actually proceed with that. In theory, you can also always proceed with such an application to the SCA after the 1 month period, but then you have to ask condemnation. So it's never really too late, but you have a prescribed period within which you have to do that. As for the date of November for the order, the Section 387 order in the tax matter, that's unfortunately a date that's been set and that's been advertised and communicated to basically the whole world out there. We were bound by available dates on the semi-urgent court roll that's available. So we already had a preference of getting a date on the semi-urgent roll because the court will not allow something like that to be dealt with on the urgent roll. Urgent is these days really treated kind of like your life and death cases. So we have, although it sounds still far in the future, but November is already considered to be semi-urgent. So we can unfortunately not move that date forward. We'll have to wait for the November date. But what we do want to make sure in the meantime is that we are ready for that date and that there's no further delays because Mr. Max has unfortunately become an expert, almost like our ex-president, Mr. Zuma, with delaying tactics and dragging things out. That's the reality. And unfortunately, that's also costing the state a lot of money. But we will make everything in our power. We will definitely make sure that we're ready for the November date.
Okay. Okay, thank you. I think that just maybe from our point of view, there's obviously questions around valuation of the Bitcoin and things like that. I think that technical detail we will need to deal with in separate questions, which we will address with yourselves. And I give an undertaking to do that with Mr. Hammer-Bester and with Pierre, and we will send through that, the information to get that. Herman, are there any? You've been very quiet and sitting there fishing. Are there any comments you would like to add to this at the moment? I still have a question for you. I'd like to ask because I think we need to roll back to somewhere around May of 2022 when there was an estimate made of how much total Bitcoin there is still claimable, which is being held by 18 top people who are winners and includes the Marks and possibly includes our Mr. Steinberg. But Herman, just to give you the floor to give an opportunity to chat there.
Yeah, I can maybe just try and assist with regards to the liquidation distribution account. You have asked about the timelines regarding the final liquidation and distribution account and how it works. Practically is that we lodge a first account, we can lodge a second account, we can lodge a third account, fourth, fifth, sixth, seventh, eighth. We can lodge unlimited number of accounts and then a final account. So in many liquidations where it's a small matter, you have a first and final account. Everything's taken care of in one single liquidation and distribution account, and that's the end of the story. In a matter like this, it's not possible for us to lodge an account with the objective to pay investors, those losers, before we have clarity from court on how to quantify the claims. We have calculated all the claims that have come in on the method asked in the application to court, where we've asked clarity on the quantification. Should the scheme be a Ponzi scheme? How the quantification should work? We've done the calculation on that basis on all claims, on all 5,500 claims that have been submitted before the master up to date. We've also calculated all of those claims on the basis how it would have been done if it was not a Ponzi, if it was not declared a Ponzi. So that is what Pierre has referred to earlier, where he said the calculation has been done to be able to immediately lodge an account once we get that clarity order from court on the quantification. I think that is why Pierre is saying that the application by Mr. Marks for appeal against the Ponzi order is a delay, because as long as we are not in agreement that it's a Ponzi scheme, which we know it is, that quantification of the claims cannot be done in a liquidation and distribution account. We are in the process to lodge a first account where we will deal with the dividend paid to SARS in terms of the settlement, which we will have clarity on the 2nd of November. We have the ability to check all the claims, whether they've been rejected and whether they've been approved by the master. And there's a mechanism in the Insolvency Act for the liquidators to deal with the claims, whether they've been rejected or whether they have been approved, to inform the master of the exact amount that each loser should be entitled to. And on that basis, we can very easily lodge a second account to deal with the dividends of the investors, but that we will only be able to do once the court has granted us the order on the calculation of the quantity of the claims. And that goes hand in hand on the assumption that it's a Ponzi scheme. So to put a timeline to it is very, very difficult. We are in the hands of the court to finalize the Ponzi order, judgment, to finalize that in terms of their application for leave to appeal. And we are waiting for finalization of the declaratory order in respect of the quantity of the claims based on the fact that it's a Ponzi scheme. But the number of claims we have verified and which we have compared with the back office, we think we have dealt with at least 60 to 70% of the total claims that will come in. We are arranging for a special meeting every second month to provide opportunity for the losers to lodge their claims, and we will continue with that until we have finality from court in all the outstanding litigation matters.
Herman, the question that I had, which I hear what you're saying, and I just to also convey this to our members, is we are dealing with the back office at the liquidators office on almost a weekly basis. We share our information with them. We look up information. If there are shortages of information, we go back to our members, and we work on their claims until such time as it's been clarified and that we're happy with it. One of the reasons we haven't been we have a whole lot of claims that already have got approval by the liquidators on our records as well, but we are holding back because of the declaratory order. We need to know that once that can go through, then we can pass that information on. If any of our GetaQuid members have got a query about their claims, please write to us at support@getaquid.com, because we will answer your emails. We will get back to you if you're one of our members. Normally it takes a day or two. Sometimes we have to go back to the liquidators to find out what's going on, and then to make sure that the information we've got aligns with theirs. But we are sharing databases at the moment, which makes our life a lot easier through our COG system. I just want to ask you, Herman, do you think that the number of the reclaimable amount outstanding will match the 4.6 billion, which was originally reported on around about the 22nd of last year? I mean, I know you are sitting at a reclaim of 1.1 billion at the moment. Please correct my figures if they're wrong. Is it possible that by the time you've worked through all the assets of everybody who still owes you money at this stage, the winners and the perpetrators of this scheme, is it possible that you would recover another 2 or 3 billion? Is that a possibility, or is that at that stage a misconception?
No, I don't think it's a misconception. I won't be as bullish as to throw numbers around or values around, but we have gone through an exercise to determine the exact number of accounts which we need to collect winnings from, if I can call it that. Those amounts which we need to claim back in terms of the Insolvency Act from those winners. And we are going through a structured process to issue summons against those winners between now and towards the end of January, February next year. The number of accounts, which is divided up in different classes of winners per number of Bitcoin, is between 28 and 30,000 accounts, and theoretically the potential collection on paper is in the region of 4 billion rand. That is on the assumption that the funds are still available. It's still in the hands of those winners who we need to collect from, and that obviously depends on a lot of variables, and that is a moving target. But yeah, maybe Pierre can comment on the potential collections that we are looking at, taking all the winners into consideration.
I just want to stand there just for 1 minute. Sorry, Pierre. I just want to stand there because I think there's a really important concept here, and I want you to tell me if I've got this interpretation correct. So we have people who are net winners, and my what I've been saying to the net winners all along is sit down with the liquidators and make agreements with them how that's going to be sorted out and how that can be settled out, because that's in your best interest. From what we've seen in the court case and what we've heard here tonight, and I'd ask Hendrik to comment on that as well, is there's no doubt in my mind that the Ponzi scheme, that it's very, very, very unlikely that the Ponzi scheme a judgment will be changed. Whether it's delayed, whether it's frustrated, that's not the point. It will not be changed. I can't see that happening. In the meantime, all that's happening is the longer this is frustrated by the net winners and by certain people like the Marxists, is costing the investors more and more money. That's what's happening, because the more this is frustrated, the more this is talked about, the more money it costs in the end. And it just delays this. And I say this with tongue in cheek. It costs 130 million to get us to where we are now. That's your cost. And we are sitting with, if this is delayed for another year, we've got another 130 million coming off that could have been paid out to investors. And so this will carry on until such time as you can issue your accounts. Now, there's two things that happen here. The more it's frustrated, I would say to the net winners, look, guys, if you were innocent, if you did it, get there, make the arrangements. And I invite Mr. Marx and whoever else, Poseidon, Johan Steinberg, anybody else, all those other 18 top people, get this sorted out for us so that it doesn't cost all this money. That's my appeal to you guys. Okay, make agreements, settle it out. Go and sit down with the liquidators and settle it out. And the problem that I see as well is once we get to the stage where you can make a provisional dividend payment, you are going to close out certain accounts. So you will have evaluated what the net losers are, and you will make your dividend payment. Then if somebody comes along later, you can't go back and make that dividend payment, but you can give them the extra amount, and that pot can be depleted. That's the way I see it. Would you like to comment on that, Herman, while I was...
Yeah. And before Pierre comments, I just want to mention that the costs up to date are not going to be repeated year after year or on whatever basis. Just remember the costs up to date in respect of certain inquiries that we needed to have in order to be able to go to court and ask for a clarity on the Ponzi, on the scheme being an illegal Ponzi scheme, that those costs are all once off. The fact that a certain amount of costs have been incurred is not to say it's going to be repeated. There will be further costs in further collections as far as we need to issue summons and go through court processes in order to collect the funds. You are absolutely correct in saying the more winners come forward and make some form of arrangement, and we don't need to go to court to squeeze the funds out of them, will save everyone money. But the costs that we've had in all the applications that were brought up to date will not be repeated. It's not going to be another 130 million, just to use the number that you've used. It's not another X amount of money that will be spent going forward. That is definitely not the case. We will deal with each collection on its own merit, and where there is potential to settle, we will consider a settlement and we will go forward. But the funds that were used to pay for what we have achieved up to date will be an investment going forward. And as far as we get those court orders, and as far as they stand and they are unopposed, that is the basis upon which we can go forward.
Okay, thank you for that, Herman. Pierre, did you put your hand up just now? Yes, Pierre.
No, I just thought Herman was prompting me to say something, but I think I can add something of value. to the issue of costs. It's true that a lot of money has been spent, but as I haven't explained it, I can describe it as the building blocks that we had to get in place in order to get this estate to a point where we can now start collecting money. So definitely we are going to spend a lot of money going forward, but it's not going to be money on the same issues that we had to spend in order to get us this far. We've actually spent very limited amounts of money thus far in proactive legal action to recover funds, especially from the winners. We've started with a small group, and we've done a lot of interrogations. But the next phase where we're going to spend money is going to be on the actual active pursuit of recoveries. So at least from going forward, if we spend money, it's going to be to get something back. It's not just going to be to get a certain building block in place, if you can describe it.
And Pierre, can I ask you that you make sure that they pay for the cost of recovering that money? So all those guys who don't come to the table, you make sure that they pay for getting that money back.
Well, absolutely, Chris. What we will be doing is we are going to definitely invite people, and I think you've put it out there, and we've also been saying this on numerous forums, is to approach the liquidators and put up your hand and say, I was a winner and I want to make an arrangement, I want to settle. The liquidators are they have the powers to consider each offer to settle on its merits and to come to a commercial sensible settlement. So they are so they do have the legal powers to say to somebody, you own X amount, but because you're saving us money, not having to come after you, and considering your specific personal financial position, we are allowed and we are prepared to settle with you on a lesser for a lesser amount. But if we're going to have to spend money and start having to appoint tracers and private investigators to get hold of people, then obviously the room for a settlement or the leeway for a settlement is going to be, obviously that's going to fall away, and we're going to definitely go for the full amounts.
Can I? Okay, I've got one last question for you. I just want Hendrik. I think Hendrik has got. Sorry, Hendrik. Have you got something you want to add, Hendrik?
Yes, it's also very important that the net losers or net equity losers do submit a claim forms to assist the liquidators as to determine what is the claim amounts received against the estate, so that at a later stage you will be able to determine when they start paying dividends after the judgment, what amount they will be able to pay out. So I'd like to encourage everyone, because I know there's people that say they don't trust the liquidators and everything. I'd like to urge people like that to come to the party, put in your claim, because it's going to be to your own benefit as a net equity loser. Also, a lot of people did indicate that they were net winners. They really believed that this was a valid investment scheme and it was a honest business. But as we all know, the court now made a ruling with that regard. And as Pierre said correctly, it will cost a lot of money and funds to go after people. Rather come to the party, rather say what you've got, say what you're able to pay, make arrangements with the liquidators, except that it will be in your own interest that, except for getting a letter of demand and being sequestrated at the end of the day, that if you put your financial situation on the table to them, they will be able to consider what will be a fair settlement to the best interest of the investors, but also for a net winner, depending on your financial circumstances. Chris, and as you said, we've reached that stage where it doesn't help we fight each other in court. It's the best interest of everyone who invested here to ensure that justice is done now, and that we are able to take hands with the appointed liquidators and ensure this liquidation is done smoothly and in the best interest of everyone. Thank you.
Chris, if I can maybe just add to what Hendrik has said, there's two issues. The first one is that many of the costs spent, which you have referred to earlier,
Yes.
will be recouped in the orders that we get to the advantage of the company in liquidation. Not those costs we have paid in respect of interrogations and investigations and forensic experts, but definitely in respect to those costs we had to go to court with and appoint advocates, and where applications have been opposed. Those costs which we can recoup might be substantial. That's the first point. And the second point, which I really want to support Advocate van Staden, is that through the GetaQuid group, obviously there's an infrastructure and a mechanism where losers can be assisted. by lodging claims, and those claims can be verified. And then obviously, with regards to winners, there can be a channel where we can accommodate specific questions and requests to consider a potential offer or to set the table for a net winner, be able to communicate with the liquidators without it being a hostile environment where applications and summonses are issued.
Herman, I want to just reiterate this. What we have been doing is when you subpoena someone or something, they come to us. And what we often do is we then reconcile that account, because most people don't know how to do that with our communication with the liquidators. So we've had numerous net winners come to us where we've helped them reconsolidate their accounts and then help them to get a solicitor and to go then set up a solicitor to go with them to start the negotiation with yourselves. And we do offer that facility. We've got a lot of people who've been innocent. I just want to make one other thing very clear to everybody. Guys, everybody heard that tonight. This is on both sides of the table. Nobody has been able to produce any profits from this trading that didn't take place. That's the end of it. If you want to say, well, they did trade and they made a loss and therefore it was trading, the fact that information was devoid of the actual platform and wasn't reflected on the platform means the platform was completely bogus. The platform was only set up there to draw more people in and to scam them out of their funds. And unfortunately, there's a lot of people who participated in promoting that in complete innocence. So I believe that that's the truth. There's a lot of people who brought their families in really thinking, well, this is the answer. Look, there it is. It's on the computer. That computer was nonsense. It wasn't true at all. So please, guys, we are sitting with something that needs to be resolved. Let's work together to get it resolved. And if the Marxes and the Steinbergs and all the rest of those people and everybody else who's involved at the top are really such nice people as they told us they were right at the beginning and all of that, just come to the table, sit down with us, put the money in your solicitor's trust account, show him the records you've got. Let's settle this thing, because it's a give and take on both sides, and we've got to try to get this resolved. I'm going to just give everybody a last word, and then what will happen is Yolanda and I will field some questions. I know the rest of the people want to go think. Anton, you've been very quiet, so I'm going to let you ask a question if you've got something you want to say. Anton, is there anything you'd like to contribute tonight?
Hi, Chris. Hope you're well. My first question that I get a lot is, what percentage can we look at in a return? And secondly, where does the liquidators have a page or something where investors can go check if their claims were approved or not? Thirdly, are there any feedback on Johan Steinberg? Are they looking for him? What's the story there? And fourthly, are there criminal cases being opened against the top leaders? Okay.
I'm going to ask Herman if you could maybe just address those as briefly as you can, Herman, because I know you guys want to go. Herman and Pierre, each one of you get a turn. Herman, would you like to address some of those quickly?
Jan, on Steinberg, I know there's a lot of hard work being done behind the scenes. We've taken hands with Hendrik van Staden on trying to see what options are available in Brazil for maybe an interrogation of Mr. Steinberg over and above all the formalities that the Hawks need to be attended to, and which we are all trying to assist them with. That's on the one hand. On the other hand, the criminal charges we are not really involved with. I get questions from the Hawks on a daily level from individual investors who have lodged laid criminal charges against whoever they wanted to, and we are assisting in that regard. From our side, our focus obviously is on going after the directors and the individuals involved with the planning of the scheme in their personal capacities, and that will take some time, but there's substantial progress in that regard. Those are the two aspects I want to comment on.
I think the one question there for you, Herman, which maybe we can address, is the publication of whose claims have been approved by the master. Is there something we can expect in that regard at some time?
Yeah, definitely.
And
definitely.
Yeah,
definitely. We have what we call a distribution page. So we have a distribution page with about 4,000 claims which have been approved, which we intend to include in the first liquidation account. We have websites available where we can identify claims that we have verified. It's something we can maybe consider to discuss on a steering committee between us, Vilanda's office and the liquidators, and I mean GetaQuid, to make that available on a website.
Okay, yes, I'll undertake to work with you.
But to that extent as well, we deal with inquiries every day. Between the 8 liquidators, we have staff members answering emails on a daily basis, and if it's through through your group, it's so much easier to inform somebody to say, yes, I've provided the liquidators with the original claim, but I haven't sent it electronically. Please confirm if it is logged and whether it's on the claim register. We email back and say, yes, your claim is number 2193. It's on the list. Your claim is in order.
Yeah. No, and we can make that available to our individual. But I think we must put a way of getting that out to people so they can inquire. Maybe set up a site so they can log in and inquire what's going on with their thing. Have an update. I can do that. We can do that. I'll give an undertaking to get that done. Then, Pierre, any last comments from you? Herman, sorry, is there anything else that you wanted to discuss?
No, thank you for the opportunity.
No, thank you so much for attending. Really appreciate that. Okay, Pierre, anything? Pierre?
Chris, I don't think there's anything else that needs to be addressed by me, unless you've got something specific for me.
No, I think we're good. Hendrik, have you got anything you're going to throw a brick at Pierre at this stage?
I just want to say thank you very much for the liquidators, at least one representative here to be present, because there was a lot of speculation, as it was felt previously by some of the investors that there was no clear communication. So I just want to say thank you very much for that. It just gives more belief in the liquidation process, and that the people can trust the liquidators when they get the necessary feedback. Thank you again. It's very much appreciated.
Yeah. Now, I also want to thank everybody. Anton, one last thing from you. I see you've got your hand up.
Yes, Chris, sorry, I know this question might be difficult. If you go to GetaQuid standard, I would like to go. And then secondly, I know this is a difficult question, but what percentage are we looking at approximately as a return?
I think Herman can address that. He did address it in a discussion previously. And Herman, if you want to just address that.
At this point in time, we have available funds that calculate a dividend of approximately 50 to 60 cents in the rand. That is a moving target for the following reasons. If we receive another 5,000 claims, that 50 to 60 cents will be reduced substantially. We don't expect to get another 5,000 claims. It's difficult to say, but I will be surprised if we get more than 3,000 claims in addition to what we already have. So the target is not only moving in one direction. The dividend is reduced by the more claims we get, and the dividend can be increased by the successful collections we are able to make. On a net cost basis, obviously. Yeah. So that's moving around, but 50 cents, I think, is a fair assumption at this time, taking all the moving parts into consideration.
And if you recover that 4 billion, then the people are actually going to get 200% back, right, Herman?
Yeah, we'll see.
Okay, thank you very much. I think
the
panel can excuse themselves if they want to. Anton, you can stay on if you want. We'll just, Yolanda, field some questions, and if there are questions from people. Thank you very much, Hendrik. Thank you, Pierre. Thank you, Anton. Thank you, Herman. Yeah, Anton, you can stay.
Thank you, guys. Bye-bye. Bye-bye.
Thank you.
Thank you. Thank you. Thanks, guys.
Okay, I have a question from Paris Wonderful. Let me just find that question. I said we will deal with that in the question and answer section. So let me just find it. Okay. What he said is, what happens to the net losers that are sued to return funds they withdrew, but still lost big?
Okay.
So basically it comes down to, as I understand it, the guys in the middle, not the net winners or not the net losers, those who made deposits and withdrew funds. And I would have actually liked the liquidators to discuss that. But hopefully, Hendrik, you can shed some light on that.
Yes. Firstly, there's the big question is we're waiting for that judgment on what is the amounts that will be utilized to determine the claim. Will it be Bitcoin in minus Bitcoin out, or will it be the Bitcoin value on the day deposited minus the Bitcoin value of the amount that was deducted during the process? So as soon as we get clarity on that, then one will be able to give a clear answer. However, there is another thing in our law, and we've discussed it with the liquidators, and that is that 6 months prior to liquidation, if you withdrew funds, you are liable to bring that funds back, even if you are a net loser. So we all understand the predicament which it will leave the investors in. And as such, many people did withdraw prior to August. And then when Mr. Ulrich Roux came on the YouTube and told everyone, but it's a legitimate company, it's a legitimate business, a lot of people then reinvested their funds into MTI. And they are not able to firstly repay before they can claim. That's the reality of the financial position of people outside there. And I did discuss it with the liquidators, and they will look into it and see how we can accommodate, because it doesn't help they go and take action against net losers, which will only financially ruin the person, or the person cannot even repay it, and the cost to attempt to recoup it is not worth the effort and the cost associated with. So the undertaking given by the liquidators that they will look into that is heartwarmingly, because they do understand the position in which many people ended up due to wrong information and the fact that people really believed this was legitimate business, and they deposited large amount of funds into MTI.
Yeah, I had similar discussion with the liquidators, and they did indicate that under those circumstances, if somebody had withdrawn money and maybe it hadn't withdrawn all their money, and then now they don't need to, and according to law they need to repay it before they can get paid out. But the liquidators are prepared to accommodate people, and we'll have to look at all those circumstances. And I would suggest that we do a full evaluation and then discuss it with the legal team on how to approach the liquidators in terms thereof. I know there are a lot of people who are going to be in that position as well, where they had a partial withdrawal, which they can't repay at this stage of the game. And that shouldn't jeopardize them getting the rest of their funds. I've had a similar discussion. Yolanda, anything else at this stage? I mean, there are lots of general questions which we will need to answer, which we repeated, like when do I get my money and that sort of stuff. But I think we've covered most of those points. Yolanda?
Yes, I do not have any really questions. There's one that says, if our claims have been approved, what is the next step? I.e., what do you need from me to be ready?
Well, the best thing we can do is when we get the approval from the liquidators, we obviously will inform the people with regard to that, as we have done in the past. And then that documentation just stays on file, and we keep a record of that documentation and keep it backed up, because it's on the liquidators. And then we have to wait for the court and the court cases to settle before the actual interim dividends and all the rest of the payouts will happen. I think at this stage of the game, we've got to try and do everything we can to talk to everybody we can, and this is for everybody, is to stop this appeal that's happening at the moment. It's a completely pointless exercise, and it's just going to frustrate our time. That's all it does at the end of the day. I really think now is the time to settle this out and call it a day and get on with it, with our lives. Hendrik, have you got anything else you wanted to discuss tonight?
Yeah, I just want to encourage everyone not to give up hope.
No.
There is light at the end of the tunnel, and luckily it's not the train smash that's coming for you. So submit your claims as net losers or net equity losers, and as net winners, approach the liquidators. Get someone you trust who can negotiate on your behalf if you're not easy with that. And I'm sure, Chris, that now in future, and Anton, you as well, that we will be kept informed by the liquidators, unlike which happened in the past. And I'm sure we will now be able to build a trust relationship, and we will now be able to monitor what they are doing and have eyes on everything, because previously there was nothing like that. And once people start working together, trusting each other, and we are able to throw an eye over actions that they do, then we will be able to give feedback which is accurate and facts that are correct. Thank you, Chris.
Thank you, Hendrik. Yeah, and I want to thank you as well, Hendrik. I know you've done a lot of work to make this possible for all of us. Really, thank you a lot for that, for your work in the background, and putting all of this stuff on getting us into a position to be able to talk to the liquidators and getting a trust going with them. That you've been very instrumental in that, and it's working really well. The liquidators are really working well with us. Thank you for that. Anton, any last questions from you? And then I've got one or two people who've got hands up. Anton, on your questions, do you want to just field them if there's anything there that wasn't answered? And I can maybe answer from the discussions that we've been having as well.
No, everything was answered. Thank you.
All right. Okay. And then I've got some, Hendrik, you can bail if you want. I know you've got kids and all the rest to do, and a cat to look after as well, I noticed.
Yeah. Okay, everyone, have a good evening, and all of the rest, we'll speak again.
Thank you so much.
Okay, this is Anton.
Okay.
Bye.
I've got some people who've got hands up here. I'm going to try and find the hands on the thing, see if I can find a hand. Yes. Nahom? Is that Nahom?
Yes,
Yes.
Nahom. Right.
Yes.
Thanks, Chris, for all that you do. I appreciate your work and everyone else. So I'm Nahom from Canada.
Yes.
Myself and my family all invested into MTI, and it's
Yes.
an amount over 1.2 Bitcoin in total. But I created all the accounts myself and put directly into those accounts for my family and myself. So when the claims are being claimed, how do I go to do that? And on the initial claim request that was done in early 2020, I submitted the claim through email to one of those liquidators. I'm not quite sure who it was, but if I wanted to, focus them or bring them all to one liquidator, for example, you guys, GetaQuid, how do I do that? And what's the process look like?
Okay. So Nahom, the best way to go about this is to send an email to support@GetaQuid, and you can mark it for attention Yolanda. She's here at the moment. Then what will happen is we will help you consolidate all the accounts and prepare all the legal documents you need to be able to get the permission to deal on behalf of all the people involved. So we make you the parent, and then we put a whole lot of sub-accounts underneath you, and then you control the whole thing. Nobody else needs to be involved. And that's a really important principle, where you've got a lot of people. You just tell them, look, I want permission to deal with your accounts. And then we set up the legal documentation and infrastructure so that you can deal with everybody's account.
Perfect. And there was some kind of transfer of Bitcoin just before the Bitcoin crash happened in December 2020. We had transfers of Bitcoin from one account to the other, and it's possible that one of the accounts had a huge Bitcoin pile on it. So is it possible to claim from that one account instead of those multiple accounts?
No, we have to evaluate along with the liquidators each of the individual accounts, but we consolidate it all under your control, under singular control. Does that make sense?
It does, yes. So I just have to subscribe to the link that's been shared and send you an email.
Correct. Yeah.
Okay, perfect. Appreciate that. Thank you so much.
All right, you're welcome. Thank you.
Yes, I'm here. Can you hear me?
Yes, Eric, go for it.
Oh, great. I'm from the United States. I've been following along. I've been in communication with you guys, and you told me that my valuation is about 1.38 Bitcoin.
Yeah.
Can you tell me where I'm confused is, what is that Bitcoin value? Is it when the payout happens or when it happened to me back 2 years ago?
Okay, Eric, what happens is there is this thing, the declaratory order, which has been applied for. And the first thing is that why we're a little bit skeptical to go to, actual values at the moment. We need to know what the outcome is going to be of the declaratory order. And the declaratory order is how the Bitcoin will be converted into Rand value. Then what will happen is once we know that, then obviously there's a pot. So all the creditors are going to sit on the pot. And what they are saying at the moment is that they're going to pay out 50 cents in the Rand at the moment as things stand right now. So if you put in R1, you'll get 50 back. So if you put in $1, you should theoretically get 50 cents back. But if they actually manage to recover all the funds that they're talking about, that's why I mentioned the 4 billion. I mean, we're sitting at 1.1 billion, and at the moment you're getting 50 cents in the Rand. If they actually recover 2 billion, you're going to get $1.50 for every dollar you invested. So there's quite a number of things, so there's quite a bit of things that are in the mix at the moment. Yeah. But the one thing I just want to tell everybody, which is really important, we've got through the rubbish now. This is now we've swum through the quagmire now. Now we're starting to get towards the end. Now it might be some months still, but at least now there's, as Hendrik van Staden said, there's light at the end of the tunnel.
Okay, and just to have it clear again in my head. So for example, back then when it happened, it was, for me, US dollars, I would have lost about $30,000. So I can still look at that just in my head in general now that you're trying to pay back that if it was 100%.
Correct. So you would be, if you invested 30,000 under the current situation, you should be getting back around $15,000.
Right.
But that excludes the recoveries that still have to come, because they've got 4 billion in claims that need to be resolved against these people. Now, if that all comes back, you're going to get back $45,000.
Got it. Thank you very much. I appreciate your time and hard work.
No worries, Eric. You're welcome. All right, guys, I think that's us done for tonight. Please remember, you guys, all of you, maybe Anton, are you still with me?
No, yes, Chris, I'm still here.
All right. Have you got anything else you want to chat about? I know the guys send you messages and then ask you questions.
No, at this stage, I think everything has been answered.
Thanks for attending, and thanks for all your. I know you work hard at this as well, don't you? You're out on the road a lot when I'm talking to you, and you're very busy. And thank you for attending tonight. I really appreciate it. Thank you, everybody. Please, guys. If anybody needs any help, anybody doesn't know what to do, if you know about somebody who doesn't know what to do, please just send them support@GetaQuid.com. Get to us if there's problems with the fees that you need to pay and stuff like that. Just be honest with us. We're going to work. Make sure we get this solved and keep going at it. Okay, thank you very much, everybody. Thank you. Good night. Yolanda, anything on your side?
No, that is good night. Thank you so much for your support.
Thank you. Thank you, everybody. Thank you for your support. Really appreciate it. Thank you. Good night.